All right, everyone. Appreciate you joining us this afternoon. I'm Austin Smallwood, your SCR Director of Legal and Regulatory Affairs. Today, we're going to go over the 3 new forms from LR that have been updated. Those changes become effective May the 1st, as well as 5 SCR forms that have changed and will be effective on the 26th of April. That is when they will be live with all forms providers that you have and on the SCR forms page on our website. If you have any questions on anything today, I first refer you to watch, especially on the 5 SCR forms. We did videos on our YouTube page. We put those out on Friday, so refer to those. Or you can give us a call on the legal hotline, 803-772-5206, or shoot me an email at austin@screaltors.org. We are not going to be doing any sort of questions during the webinar today, but like I said, please do reach out to us if you have any questions after the material that's been presented. So the first form that we're going to go over today is the dual agency agreement. This was updated by LOR to become effective now. The change here was that they updated the portion about this language here, 40-57-310I1. That was to be in compliance with the new license law. The previous version had an outdated code section. So make sure you're using the most up-to-date form. The easiest way to know that is there is a revision date at the bottom here of 2/21. So make sure that the dual agency agreement that you're using has a revision date of 2/21 and that the code section that is in number 1 is 350. That is the only change that was made to the dual agency form. Otherwise, the form is completely the same. Very similar change that was made to designate agency. Again, at the very top here, it is now 350. That is the correct form site. And the revision date on the last page should be that 2/21. So for both designated and dual agency agreements, make sure you're using one with a revision date of 2/21 and not an older version. You do need to make sure that you're always using the most up-to-date versions of all forms. The disclosure statement, there was one change that was made to this form. This becomes effective May the 1st. This involves roofs. So this is a change that we had members bring to us, and the commission took this into consideration. So previously, the version of this question essentially asked what was the approximate year that the current roof covering was installed / modified. The issue would happen where the roof was built in 2000, but it was modified in 2010. So the date would be put in there 2010. Well, now the buyer has no idea, hey, was the roof actually built in 2010 or was it modified in 2010? So what the commission has done now is split up this question. So in A, you'll actually ask the year the roof was installed, the year the structure was built, and then in B, you will describe any leaks, repairs, or modifications that were made to that roof with the dates. That way, in the example I just gave, where it was 2000 was the year the roof was installed, it was modified in 2010, the buyer would be better informed and have all of those dates. Again, you as the licensee are not required or should not be filling out this form. This form should be filled out solely by your seller in consultation with their attorney. If they have any questions about what to fill in this blank or any other blank, they need to talk to their attorney. You should not be speaking on this form unless it's because you need to disclose a material adverse fact that your seller refuses to acknowledge. Other than that, that is the only changes to those LR forms. Those have been updated. Those will be updated on our website and all of our forms providers by the 26th of April. So now we're going to get into the 5 SCR forms that have changed. These forms changes were approved last year by the Forms Committee and your SCR leadership. They will go, like I said, they will be in effect on Monday, April 26th, so a week from today. The 5 forms SCR forms that have changed are SCR Form 518, which is the release agreement, which we're going to go over first. 504, which is the buyer sale contingency. Form 505, which is the notice of the buyer's notice form attached to the buyer sale contingency. A new form, SCR Form 500, which is how a buyer notifies the seller that their house is under contract. And as well as 330, which is our vacant land contract. So the first form we're going to go over is this release agreement of contract to buy. So this form is different than your notice of termination. The notice of termination form 313 is simply a unilateral communication. So that is either the buyer or the seller notifying the other party, hey, we no longer intend to follow through with this contract. The release agreement is only valid when both parties sign it. The intent of the release is threefold. It's going to say, hey, the contract is null and void. The second is going to say, hey, we're going to hold each other harmless, and we're going to hold everyone attached to this, including brokers, harmless. And the third is that we're going to direct the escrow agent what to do with that earnest money. A reminder, earnest money in the state of South Carolina can only be dispersed through mutual agreement of parties or a court order. So when you hear mutual agreement of the parties, they're talking about this form, SCR form 518. I always kind of say that this is the second best result you can have from a transaction. If you're not able to close, this is going to be your quickest and easiest way to move for buyer and seller both to move on. So what did we exactly change on this form? The first thing is, prior to this change, buyer, seller, and brokers had to sign this form. We just said, hey, this is really about the buyer and seller canceling their contract, buyer and seller trying to decide what to do with earnest money. So there's really no need to have brokers sign this form. So the broker signatures have been removed from this form, as well as the language saying that brokers will sign the form. However, brokers are still covered in this whole harmless language. So that harmless, the hold harmless still covers everyone involved in that transaction from any disputes arising from the transaction, but there is no requirement that the brokers sign the form. Now, the real guts of this form is really at this highlighted portion at the bottom. So just as a note, most of the changes that are made to these contracts are going to be highlighted in yellow, both on instructional videos, this webinar, and the draft versions on our website. But when the forms do go live next week, the highlights will not be there. If you do notice any syntax or spacing issues, please note that we have been working with our forms providers, and those will be polished before the forms go live on the 26th. So you will have four options for what to do with the earnest money. The first option is, hey, we're going to say $1,000 of earnest money, $1,000 to the buyer. Option two would be the $1,000 is going to the seller. Option three would be we're going to do some sort of split. So maybe 500 to buyer, 500 to seller, 750 to buyer, 250 to seller, whatever the parties agree to. Those are pretty common. You've probably been doing some combination of those three in your current practice. Option four is where the real change is in this form. So we would get calls all the time on the hotline. Hey, buyer and seller agree that they're not going to buy, the sellers are not going to sell the house to the buyer's not going to buy the house from the seller. The seller wants to sell someone else, the buyer wants to buy another house. They agree they're not going to go through this contract, but they still are fighting over the earnest money. So what can we do? We didn't previously have a form that would kind of help them out with that. So now we have this, option number four. So the parties agreed that they're going to terminate the contract, but they still dispute the release of that earnest money. So the parties request that the escrow agent file an appropriate action with the court of competent jurisdiction to resolve the dispute. And then we say that, hey, the parties should probably talk to their attorneys about whatever legal options, claims, risk they may have. So what they're going to essentially agree here is, hey, the contract is dead. We're going to hold each other harmless, and we're going to direct that escrow agent, whether that be the buyer's broker, seller's broker, or law firm. We're essentially going to hand this to them and say, hey, we want you to go file interpleader with the court because we can't essentially sort this out. A reminder that the amount in dispute, if it's $7,500 or less, will put you in magistrate court. Anything other than that will put you into circuit court. So you want to make sure that you're keeping that in mind when putting in your escrow amounts, your earnest money amounts. Make sure that you're doing appropriately there. Also, we do recommend parties try to mediate that. That's going to be much quicker, faster, cheaper. SCR is currently offering some free online mediation. So if you are interested in that program, please let us know. But this is an important note here. So a couple things: if you currently hold escrow money, and this paragraph is giving you a little bit of heartburn. A couple of suggestions would be: one, if possible, try to have a law firm hold the money. That's going to free you from having to go to court all the time and fight this out. Or, hey, if you now anticipate that more parties are going to select option four, and therefore you're going to spend more time in court, maybe we're in paragraph 5 of our contract, we have the amount of money that you will compensate the escrow agent for filing an interpleader. Maybe you increase that amount to make up for the time that will be lost. So those are the changes to Form 518. Make a note, essentially, that you want to use the most up-to-date one, and this will be live on the 26th of April. So the next form is SCR form 504. This is our buyer sales contingency. So this is the form that you use if a buyer needs to sell their current home in order to purchase the new home. So for this example, we're going to have a buyer moving from Ohio to South Carolina. And so throughout this example, when I'm talking about 504, 500, and 505 and 500, we're going to refer to the buyer's property, the Ohio house, or the South Carolina house, which is the one they are purchasing in South Carolina. Of course, this form can also be used if you're moving within South Carolina or within the same city, but just for ease of understanding, I'm going to use the buyer being from Ohio. So in this form, you will put the buyer's property. That will be the buyer's address in Ohio. The buyer will then answer a few questions about their property. Hey, is it or is it not currently under contract? And if it is, we're going to attach a ratified redacted copy to this contract to this. When doing redaction, you need to make sure that you're essentially only attaching the information that's absolutely necessary for the seller to have. So maybe that whether or not there is a contingency or not, closing date, and maybe some signatures. But I mean, the form should be largely redacted. If you have any questions on redaction, give us a call on the hotline or have your client talk to their attorney. We're going to get into in a few moments about Form 500. Like I said, that is our new form. But if the house is under contract, the buyer will deliver SCR Form 500 to the seller. We're also going to say, hey, when was the property listed? And was it listed by a brokerage firm? And is it listed on a multiple listing service? So we can kind of give the seller an idea of what efforts the buyer has taken to sell their property and how far along in the process they are. This next portion is a completely new form, new addition to the form. This was not previously in our 504 contingency. This states that the buyer's property must be under contract by a hard date. So whatever date that is, the buyer's property must be under contract. The buyer has to deliver to the seller a copy of a signed and completed SCR Form 500 within 48 hours of the ratification of the contract. If the buyer's property is not under contract by this date, then either party may terminate this contract by notice using SCR Form 313. So the reasoning behind this is, say the parties went under contract today and they had a closing date of June the 1st. But May 25th, May 26th, the buyer's property is still not even under contract. So everyone knows, hey, the buyer's not going to be able to close on their house by the time we're going to close on this house in South Carolina. So, but we still have to kind of go through the dance because maybe we made the buyer sales deadline at closing. So now the intent for this is to say, hey, at some point, it's going to be, if your house isn't under contract, there's no way you're going to meet your deadline. So let's just go ahead and get out early as opposed to dragging it out even longer. So I mentioned that buyer sale deadline. So this is saying that this contract, this contract being the contract for the South Carolina house that this is attached to, is contingent upon the marketing and closing of the sale of buyer's property, the Ohio house, no later than a hard date. Previously, we had so many calendar days prior to closing or closing here. Instead, now it is a hard date. So the buyer, you are going to sell your house in Ohio by a certain date. And then they will, within so many calendar days of closing, deliver you notice that property has closed. That shouldn't be a very big number. The buyer should obviously be pretty excited to share that information with you. If the buyer is not able to sell their Ohio house by the date above, then the buyer can terminate the contract by delivering notice using SCR Form 313. Now, I'm sure you're now wondering, well, what happens, hey, if the deadline here was, say, April 15th, and the closing date here was May 15th, but May the 1st, the Ohio contract falls through, what happens? And that's where we have this language. So if the contract on the buyer's property is terminated after the date above in Section 1, so the has to be under contract date, but before the buyer's sale deadline, this date here, then either party may terminate by delivering notice using Form 313. Now, should the property in Ohio not close by the buyer's sale deadline, then the seller can terminate this contract by using notice 313, unless the buyer can do one of two things. The buyer can show you, hey, here's cash. I can afford to buy this house without this contingency because I've got cash on hand. Or here I can show you that my financing is not contingent upon me selling my other home. Essentially, I can afford two mortgages. So absent the buyer showing you they got cash or they can afford two mortgages, then the seller can also terminate by delivering notice using Form 313 if the buyer fails to meet their buyer sales deadline. And then, of course, if buyer fails to meet either of these deadlines, then either party can terminate by delivering notice. So what is the buyer obligated to do during this time period? they actually have to try and sell their house. They have to make good faith efforts to try to sell. They need to timely inform the sellers and the brokers of pertinent information regarding the sale of their house. And they need to direct their brokers and law firms to disclose pertinent information about that property. Essentially, you've got to cooperate with the seller, and you've got to actually make good faith efforts to do that. If the buyer fails to do these, then the seller needs to talk to their attorney about what options they would like to pursue. So paragraph 4 is really sort of the guts and the teeth in this form. And there were a few big changes that were made to this. So in the previous version, the seller could essentially start the clock on a seller, on a buyer, by receiving a backup offer. This has now been changed to a backup. They have to have accepted a backup contract. So the seller can continue to market their property even though they've gone under contract with the Ohio buyer. And at any point, if the seller gets a has accepted a backup contract, then they will go to the Ohio buyer and say within, hey, so many calendar days, you need to show us one of these 4, I think, that you've met one of these 4 criteria. Because this is going to determine what happens with this backup contract. So the first thing is going to be, so there's sort of two schools of thought with this. There's A and B. These are things that the buyer can do to remain on the primary contract. And C and D will mean that they're either going into backup position or they're going to be out completely. So in A, the buyer can deliver to the seller a form 500 showing, hey, my Ohio house is still under contract, set to close. The only thing we're contingent on is financing because, like an SCR's contract, financing actually runs through closing. So you would need to show the seller, hey, I'm still that house we've been negotiating on, that Ohio house, it's still set to close. So you cannot be bumped out of primary position if you can show that. Or B, hey, I've either got cash or I can afford 2 mortgages, so I can drop this sales contingency. If the buyer does A or B, then they remain the primary contract, and any subsequent backup contract simply remains a backup contract. Or there's C and D. C would be the Ohio buyer goes, hey, why don't I just swap places? I'm still trying to work out my deal on my house in Ohio. Why doesn't this new contract become primary and I'll go to backup position? Or D, we tried to make this work, but we couldn't. So we're going to terminate by delivering notice using form 313. And then we'll need to use form 518, which we've already gone over to go over any sort of earnest money dispute. Now, these options in paragraph 4, you'll make those selections in SCR form 505, which is the companion form to this, what we're going to go over in a second. But essentially, those are the options there that can be presented to a buyer should a seller receive accept a backup contract. And then, like all of our forms, we now have 4 buyer lines and 4 seller lines to give more room there. So form 505 is what's used if we get to the provisions of paragraph 4 and SCR form 504. So at this point, the seller is going to give you the buyer notice, hey, I've accepted a backup contract. And now we're going to put the buyer on the clock based on those timelines that we put in paragraph 4 of form 504. So the first thing that's going to happen on this form is the seller is going to make one of 2 choices here where it says seller notice options. The first is they're going to let the buyer know, hey, I've accepted a backup contract. Your timeline from SCR form 504 is kicked in. And by the way, here's a redacted subsequent contract here's a redacted copy of that backup contract, so you know that I actually accepted a backup contract. Again, with redactions, less is, as much redaction as possible. Only the absolute necessary information. Give a call to the hotline or your attorney if you have any questions. Or the other option could be the seller says, hey, I accepted a backup contract, but I still like yours more. So you're still in primary position, but I just kind of want to let you know that I have a backup contract on this house. So those are the 2 seller options. Now we're going to go to the buyer options. The buyer should only choose one of these options, and they must do so within that time frame set forth in form 504, or they essentially are going to be liable to have the contract terminated. So these first 3 boxes are where I mentioned these are A and B. This is what the options that the buyer can make to remain their primary contract. So if the buyer wants to remain the primary contract, they need to be able to satisfy the contingencies of one of these 3 boxes here. If they're not able to meet one of these 3 criteria, then they're not going to be able to remain the primary contract. And so what are those criteria again? The first is, hey, my Ohio house is still under contract set to close. The only thing we're waiting on is financing. Here's a copy of SCR Form 500 along with a redacted contract for my house in Ohio, showing you the only thing we're waiting on is financing. Or, hey, seller, here's verification of cash that I got a cash to close. I can close using cash. Or here's verification from my lender showing you that I can afford 2 mortgages. If the buyer can do one of those 3 things, then they remain in primary position. If not, then they're going to check one of these next 2 boxes, which is that, option C, where we agree to essentially swap places with the buyer, and we now become the backup contract. If you're using a backup contract, make sure you're using the backup clause, which is an SCR Form 391. Or the buyer says, hey, we couldn't make it work. We're going to terminate by delivering notice of using Form 313. If the buyer does not meet any of these deadlines, then either party can terminate by using SCR Form 313. So this form needs to be used in conjunction with Form 504. So if you kind of keep your forms in your office, that similar forms are, kind of understanding of, hey, if we're going to use 504, we're probably at some point going to need to use 505. So make sure you're familiar with Form 505. And again, 2 buyer lines, 2 seller lines on this one. So this is the SCR Form 500. This is the new form that we've been discussing. So anytime you see SCR Form 500, a prompt to use that in either SCR Form 504 or 505, this is the form to use. This is the form that a buyer is going to give in notice of an accepted offer. So previously, we had, hey, the buyer's going to give you notice of that they've accepted a contract, but it was sort of, how do we do that? Do we do that through an addendum? Do we do that through an email? Do we do that through a text message? So now we have a formal form for you to use. It's got to be the shortest form in the SCR forms library. So it's simply going to be, buyer has accepted on their offer on their property at 123 Main Street, Anytown, Ohio on April 19th. And the property is set to close on or before May 15th. And then we're going to say whether or not we have attached a redacted copy of the contract. Now, again, if we're using this form with Form 505, we must attach a redacted contract. So if we're essentially trying to keep a seller from kicking us out of primary position by using this form, then we have an obligation to show the seller that, hey, this contract that I'm telling you about is actually a legitimate, and it does meet all those criteria, meaning that the only thing we're waiting on is that addendum, is that financing contingency. And then we have 4 buyer lines. The seller does not need to sign this form since it's a buyer notice. It is a unilateral communication from the buyer to the seller. So a seller will never sign this form. And then lastly, we have the changes to SCR Form 330. This is our general lots and acreage form, but this form can also be used for like a boat slip or a similar transaction. The goal behind this change was to make this match up as closely as possible to the changes that we made to SCR Forms 300 and 310, the residential sales contracts in 2020. So the majority of these changes are going to be very similar to the ones you're already familiar with, hopefully from the 2020 revisions. Obviously, with this being a land contract, there are some differences between that and a basic residential sale, and I'll try to point those out as we go along. So as with all of our residential contracts, the easiest way to make sure you're using the most up-to-date one is there will be this language about legal advice at the very top of the contract. Prior to the most recent revisions, that was at the very back of the contract. The forms committee said, hey, it's so important to let everybody know at the very beginning that, hey, you need to get legal advice. If you have any questions, that we move that to the very top of the contract. So if you do not see this at the top of 300, 310, or starting Monday, 330, know you are using an out-of-date version. You need to use the most up-to-date version of all SCR forms. Like the residential contract changes we made last year, we have removed business days, so there will no longer be any business days in any residential or land contracts produced by SCR. They will now be all either calendar days or a hard date, just like we did in 300 and 310. Again, like 300 and 310, we will have the acknowledgement by a buyer or seller that they have received the disclosure of brokerage relationship form and that they are receiving either client or customer service in the transaction. Very similar to we did in 300 and 310, we have removed the automatic extension. There will no longer be an automatic extension. So if the parties need to change the closing date, they either need to do a pen and ink change on this line, or they need to copy this entire sentence, starting with the closing in quotation marks and ending with closing date in quotation marks to a separate addendum and copy that verbatim. Otherwise, pen and ink change, those would be the only two ways to change that. The next things we changed here is obviously with this being vacant land and not residential property, we kind of made this a little bit more land friendly. So they're going to say they're going to leave you a vacant property that is free, is a vacant property. We don't worry about reasonably clean or free debris because that may be sometimes hard to do with, timberland or things of that sort. But the seller is required to remove all man-made items from the property unless otherwise agreed upon in writing by the parties. So the seller can't just leave, tires or sheds or whatever they would like on there unless the buyer has specifically agreed with the seller to leave those on there. Earnest money, this is going to be very similar to, this is just like the residential form. Total amount of money, it's either going to be accompanying offer or will be paid by 6 p.m. on a hard date. If earnest money is not delivered by that agreed upon date, then the seller can terminate the contract by delivering notice of termination to the buyer. Again, earnest money can only be dispersed through mutual agreement of the parties or a court order. So make sure that you are following all the earnest money rules regarding this. Transaction costs. This is exactly the same as in the residential contract. Clearly lays out what the buyer costs are, what the seller costs are. There's a provision about owners associations and transfer fees. Again, make sure that you are checking one of these two boxes, because if you do not, it defaults to a seller cost. We did move up this language that is in red. This has always been in our contract, but it's been sort of buried in the adjustments paragraph, but we're getting more calls about special assessments on the hotline, so we moved it up to a more prevalent position. This is simply saying that, hey, any special assessments approved prior to closing are going to be the responsibility of the seller. Any special assessments approved after closing are going to be those of the buyer. So just make sure that parties are aware of that if there's any special assessments involved in the property. And then the seller is going to pay buyer's transaction costs not to exceed a certain amount. We got rid of the portion about the percentage. Make sure that they are aware that not to exceed are the key words there. So if there are $10,000 in cost and they put $15,000 here, they're not getting $15,000, they're going to get 10. They don't get an extra $5,000 to spend as they wish. But likewise, also, if they put 10 in, if they put 15 in here and it's only, if they put 10 in here and it was actually 15, then the buyer is going to pick up that remaining 5. Financing. These were the exact same changes we made to the residential forms last year. Maximum percentage of purchase price. Reminder that buyer will apply for financing by a hard date, and they're going to give you a pre-final loan approval with no unreasonable asset, credit, or income conditions by a hard date. If the buyer changes their lender during the financing period is when you apply for financing through closing, they need to notify the seller of that in writing within so many calendar days. Now, if, as a result of them changing the lender, the closing date changes, going back to we got rid of the automatic extension, that is going to be something that has to be agreed upon by the parties. A buyer cannot unilaterally change that closing date. Inspections, this is to add the same language that was added to the residential form last year about allowing a final walkthrough within 48 hours prior to the closing. Appraisal, the only change here was that previously it said business days, it is now calendar days. A reminder with the appraisal contingency, if the appraisal comes in lower than the purchase price, the seller has 5 days to essentially let the buyer know whether they agree to reduce the price to the appraised value. If the seller does not, then the buyer can either proceed to closing or terminate by delivering notice. But it does not work up. So if the property appraises for more than the purchase price, then the purchase price will remain the purchase price. The appraised value contingency only works if the appraisal comes in lower than the purchase price. 10 and 11 remained unchanged. This is simply reminding parties that they need to have the appropriate individual survey, title inspections, wetlands, etc. And anything that survives is meant to survive this transaction after closing will say so and will be binding on the parties. Unlike the residential contract where there are 3 different options for repairs, in a land deal, there's only one, and that is due diligence. But we did make sure that the due diligence language in this is exactly the same as the due diligence language in the residential form. So again, our due diligence is an all-in timeline. So by 6 p.m. on a hard date, the buyer needs to have done all their inspections, sent their request, and either agreed to terms with the seller for repairs, agreed to an extension, or has terminated by delivering notice of termination and the termination fee. Failure to do one of those three things will result in an as-is contract in regards to repairs. Now, there are a number of contingencies in this contract that are outside of the due diligence period, and they have their own sort of criteria, but this is sort of the termination fee would only be owed if you terminated during the due diligence period for due diligence reasons. If you terminate for one of the other contingencies we're about to go over, then that termination fee would not be owed. Again, there's no discussion of earnest money in here. The termination fee and the earnest money are two completely separate pots of money. You should not be pulling termination fees out of earnest money. Fire casualty injury, we have upgraded that from 5 days to 14 days. Understanding with storms and things of that sort and evacuation, sometimes it's impossible to even get to the property within 5 days. So the forms committee said, hey, let's increase that to 14 to give parties actually a chance to review any damage that may have occurred. The next few addenda or contingencies you'll see, we kept them the same, except for we changed them from business days to calendar days. And due to recent real estate commission rulings about earnest money only be dispersed through mutual agreement parties or a court order, we have removed all the contractual disbursement of earnest money language from this contract. So that is what the changes that were made in 14 and 15. 16, this is language that was pulled from SCR Form 391. Essentially that the seller is going to provide copies of deed restrictions by a set date. Do note, as a licensee, that is not your job to pull deed restrictions. In fact, it could be argued that the pulling of deeds or restrictions is the practice of law. So that should be done solely in consultation with their seller, in consultation with their attorney. You should not be pulling those as their real estate licensee. 17, same changes that were made to paragraphs 14 and 15, calendar days, and removing that earnest money language. 18, this is the soil, water test, and water issues language from Form 391 that we moved to SCR Form 330. So this is not new language to SCR, it is new language to this form, but that is the exact verbiage that is in our current Form 391. 19, just removal of contractual disbursement of earnest money language there. 25, this is a new paragraph we did for rollback taxes. Really is going to give now the parties three options. Either the seller is going to pay for any rollback taxes at closing, the buyer is going to pay the taxes when they're assessed, and the seller has no responsibility for rollback taxes, or the parties are going to agree to split them. Make sure, especially if someone's going to be converting raw land to something else, make sure that they're very aware of what the rollback tax issues are. Make sure that they're consulting with CPAs and attorneys on that. That's not something you want to advise them on. You just want to advise them that rollback taxes can be an issue. Can be an expense. Luckily, due to lobbying at the State House, it used to be a 5-year look back period. Now it is only 3, but still it can be a considerable expense to make sure that your client is talking to the appropriate attorneys and CPAs. 26, we simply removed the earnest money language from here and also changed it from business days to calendar days. 27, I like to point this paragraph out, especially in the market that we're in. This is in all of our SCR contracts. The only thing that counts is what makes it to the four corners of this document. So any sort of in-person conversations that the agents or the parties had, any sort of text messages, emails, something that's listed on the MLS does not count if it does not make it to the four corners of this document. So if it is important to the parties, they need to make sure that they actually put it as an addendum to the contract or make sure it's covered in the contract. Otherwise, that is not binding. The only thing that matters and is binding on the parties is what they agree to in the four corners of this document. Adjustments, the only change here was that we took that special assessments language and we moved it up to paragraph 6. So we did not remove that special assessments language. We simply moved it from paragraph 28 to paragraph 6. Attachments, we removed a few of the attachments that are either no longer in the SCR forms library or are not relevant to vacant land, such as occupy prior to closing or things of that sort. This is a helpful thing here. If you have attachments to a contract, make sure that you're kind of listing those out there, especially if LR was to ever knock on your door a year or so from now. It'd be a nice reference point for you to go, oh, I remember that deal we had, a 504 contingency, or we had a couple 390s on here, and that way you can kind of use that as a look back. 36, Reminder that notice is only effective if it's delivered to the notice address, email, fax that is on the contract. So make sure when you are communicating with parties that you're sending it to the notice address, email, or fax that is under the buyer or the seller line. That is 9 times out of 10, if not higher, not going to be the buyer and the seller's address, email, or fax. That is going to be your office. But make sure you're having that conversation with your buyer or seller. Hey, where do you want all contracts sent to? Where do you want that or termination fee for due diligence dropped off? Things of that sort. And of course, if things are only considered validly, you're only considered to have notice of it if it has been delivered to that notice address, email, or fax. A reminder with paragraph 37 that you're not going to wire email wiring instructions. Understand that there can be surveillance and make sure that everyone is looking at that disclosure of brokerage relationship form, agency forms, and that your client has a copy of all those, has been given an adequate explanation of them, and has been referred to legal counsel for any questions. Expiration of offer. This is the exact verbiage that was in 300 and 310. We moved to this, simply saying that this offer will expire automatically if no action is taken by either party 30 calendar days after the offer submittal. But please put an offer rejection time in there and make sure it's appropriate and reasonable. Don't put 3 hours in there if you can help it, because the seller may not even get it within the 3 hours, and the buyer and the seller's agent will have done nothing wrong, but you kind of weren't working in the best interest of your client. So make sure you're putting a date in there. Make sure it's reasonable. Understand, as the sending party, you can always rescind it at a time prior to this. But once the timeline is passed, you do have sort of a dead contract. Change this again to calendar days. We added 4 buyer lines, 4 seller lines, and we have those notice address, email, fax that I referenced earlier. And then this is where the buyer and the seller's agent will put their relevant information, license number, office code, email, phone number, etc. So those are the forms that are changes that will be effective. Like I said, the 5 SCR forms, so form 518, 504, 505, 500, and 330, those will be effective on Monday, April 26th. That's also when you should see those other 3 LOR forms. They are effective May 1st. You can start using them prior, but they should be available if they are not already in all of your forms providers by that date of the 26th. If you have any questions on any of this, again, we did do private or individual videos for each of these forms. Those are available on our SCR YouTube page. And so those would be the best way to kind of go over if you have a specific question on any of these, or give us a call on the hotline. We're more than happy to answer any of those that you'll have. We can also, if you want more information, you can certainly also talk to your local board and maybe see if we can come do a virtual class for your local board as well. So that is sort of all of our new additions that we have at this time. Like I said, if you all have any questions, feel free to reach out to us on the hotline.